Please, Your Lordship. Lordship, I beg to make a mention item 8. Item number 8. Lordship, I'm praying for 2 weeks accommodation, Your Lordship, due to personal difficulties of the senior counsel, Your Lordship.
Why 2 weeks? I'll give you 3 weeks, 4 weeks, 5 weeks also.
Lordship.
On pre-made by the appellant seeking accommodation in this matter. That is adjourned. This is after 3 weeks.
Similar prayer for item number 9, Your Lordship.
Item number 9, I think we have decided that this matter is to be heard positively.
That was initially because...
Was it there's some talk of settlement kind of?
Talk of settlement, my client has met Mr. Paul also, but nothing concrete has come up, my lord.
This is with regard to a pathway or something?
It's a pathway, just it's an approach road.
Approach road.
To my, which leads to my land. So they are claiming it. The trial court in the first appeal has reversed the judgment of the trial court below, my lord. The appellate court.
Where's the suit land?
Suit land is Limekra, my lord.
Limekra?
Bhagyakul.
Okay.
Lord, I have raised also the point of maintainability because, my lord, this is a suit, my lord. Judgment decree was passed, then I filed a first appeal before the appellate court, before the judge discouncil court. So that judgment was of the trial court was reversed. So they had come by way of civil division, my lord. Whether civil division will be maintainable, my lord, in view of the fact that the judgment on order has been passed in the first appeal.
It should have been a second appeal. Should have been.
Cannot come by way of civil division.
You should have raised the issue of maintainability at the. Have you taken this stand?
No, I have raised it because this is a civil division. I cannot file anything. On the earlier occasion also I have raised this point. The maintainability of the civil division. Madam can list it after a week. Let them satisfy this honorable court whether the civil division is maintainable or not. Otherwise, if they are ready, they can.
Oh, you see, this court more often than not is not inclined to take matter piecemeal. We will hear the whole petition as I will hear the petition as a whole. Issue of maintainability to be taken up and maybe decided.
Yeah.
If the court finds that it's not maintainable, matter ends there. If it is maintainable, then the merits of the case will be clear. Pre-made by the petitioner, this is matter of 2 weeks.
From daily list, item number 1.
As per the last order, madam, the petitioner is supposed to take a step on respond number 2.
Lordship, we have taken step. Lordship, it was returned back, Your Lordship. Lordship will file an affidavit of service, Your Lordship. Will file a affidavit of service, Your Lordship. With regard to service of respondent number 2.
You say return back, now you say file affidavit of service. What do you mean? When it has returned back, means it has not been affected.
Lordship.
Where is the issue?
We'll take fresh steps, Your Lordship. My apology, Lordship.
Mr. Counsel for the petitioner has submitted that the notice issued upon the respondent number 2 has returned unserved. It is clear that fresh notice may be allowed to be issued on pre-made, it seems allowed. This is matter of 2 weeks. In the meantime, the interim order pass will continue until the next date fix.
Item number 2.
Lordship, service with regard to respondent number 2, 3 and 4 is delivered, Your Lordship.
Have you filed the affidavit of service?
No, Your Lordship. I'm praying that will be fine.
Here the office note would say that the ID card of for respondent 2 to 4 has not been received.
Lordship, I'll file my affidavit of service, Your Lordship.
That's 224.
Lordship, 224, Your Lordship.
Mr. Letter Counsel for the petitioner has submitted that the notice issued upon the respondents number 2, 3 and 4 respectively has been affected. However, it is prayed that an affidavit of service may be allowed to be filed in this regard. As prayed for, that is allowed. As prayed for, the petitioner is allowed to file the said affidavit of service. This is matter of 1 week.
Item number 3.
May please, my lord. My lord, this here in the instant case, as I have earlier also submitted, that there is no any credible evidence to show that I am involved in this case. Your Honor, my lord, as a matter of fact, there is no any relevancy to arrest me in the instant case. Here in this instant case, my statement under section 161 has not been recorded by the police. Section 67 of the NDPS Act, 164 for confessional statement of my statement also has not been recorded. My lord, no drugs was recovered from my possession. I have not committed any.
What is the stage of the case? Charge sheet
trial?
Trial.
Yes, trial. Two prosecution witnesses has been already examined. The Caesar witness and the complainant. They have not stated this. They have not even mentioned my name in their deposition.
Have you filed a copy of those?
Yes, my lord. And Your Honor, my lord, in the last page, this 66, page 66, my name has been reflected only once in page 66, where I was charged under section 21B of NDPS Act, which is intermediate quantity.
So, Mr. Khan, what is the evidence against the petitioner?
Lordship, here, on the last day, Your Lordship, there are two things, Your Lordship. First is what is the state of the case? Excuse me. So in both the cases, Your Lordship, 6 and 7 are connected. Your Lordship has also called for the CT, so we have got the copy of the CT.
No, okay. Now, what the council is submitting is that the stage of the case is for recording of evidence.
Lordship, yes.
And 2 witnesses have been
Examined.
examined. How many witnesses are there altogether?
These 2 witnesses have been examined since April 24.
How many?
2 witness
No,
prosecution.
how many altogether? How many?
Altogether 7.
7.
My
One
lord.
case there are 6 and the other case is 7.
But only 2 from April till today.
Lordship?
From April till date, why only 2 witnesses have been examined?
Some were summoned, they could not appear. In some cases, the time was granted. According to me, Lordship, because it's a NDPS matter, Lordship, and they were involved in transportation. I read out, Your Lordship, in the last day when the matter came. I read out the relevant part and said clearly he's made a statement. Both the accused have made a statement. They were some were involved in the initial transfer of the consignment from Manipur to Shillong.
Oh, that is the. Sorry, we're talking about the. This husband-wife duo.
Husband
and wife.
Yes.
My lord, sir, the contraband was recovered from the accused number 1, Ling Hokip. 91.81 grams of heroin was recovered from her possession. Second accused is Hohoi Langhal. 105.54 grams was recovered from her.
Where are you reading from?
From this
Which?
kindly come to this page 17. This my lord. This is the FIR.
It's 17.
Page 17. Page 17. This is FIR. And my lord, my wife used to have a telephonic communications with accused number 1 and 2 because my lord, they were childhood friends and they were from the same village. So after my wife got married to me, he shifted to Churachampur. Basically, he was from Langkol village, Imphal.
Oh yes. Now, Mr. Khan, where's the CD? Where's the call diary, call details report?
Lordship, call details will not be required at this stage.
Because that's the only link.
No, that's not the link. Lordship, can you just read a relevant part of it?
Where is your?
Lordship, so far CDR is concerned, I'll come to it, Lordship. The Lordship goes through it. Substitution. 13.
Yes.
Lordship, I'm just relying on this, one of the judgment delivered by this court, Your Lordship, para 17. Para 17, 19 and 20. Para 17 answers the query, Your Lordship, based on a Supreme Court judgment. This court is already held.
No, first, let us
Yes.
establish the complicity of the accused persons.
Your Lordship, yes.
Here, there was a statement made by, I think, initially how many accused were arrested? Two persons were arrested. 2 or 1.
Two were arrested.
So the statement of one of them,
Oh, yes.
statement of this Shokhotang Taothang. So his statement says that the husband and wife are the main supplier.
Yes.
That's what he said.
Absolutely.
So that aspect of the matter has to be investigated, has to be looked into by the IO. To what extent has he confirmed, the veracity of such statement?
Lordship is correct. Be grateful, Lordship. At least that is the issue involved. Yes.
So
At this stage, Your Lordship, only 2 witnesses have been examined.
no, we are not. You see, now we are at a stage of examination of witnesses, which means that the investigation has been completed.
Completely, yes.
Charge sheet have already been filed.
Absolutely, Lordship.
So where in the charge sheet can you point out that there is direct evidence or even indirect evidence linking these 2 persons to the supply of the said
What has fallen just now from Your Lordship, the main accused has directly implicated both of them, that they were the main suppliers.
So yes.
Yes. So that is prima facie in the charge sheet. This evidence is clearly there.
See, that is what he says. It is incumbent upon the IO
Yes.
to join the dot.
Yes, Lordship is correct.
How he joins the dot, how he makes the connection, that is it's
Nothing
incumbent.
on record. Nothing
that
on
has to
record.
be
Now, Lordship, what has happened is this: when the main accused from whom it was seized, there was an independent. So the seizure part clearly says that this was the same drug he had brought from Manipur via Mizoram, and it was Nakabandi was done in a petrol pump. So that chain reaction is very clear. The question comes, from where did he get this? That gap is clearly filled during investigation by both these accused on the statement. So prima facie, Your Lordship, that the chain is completed as to where is the source. And Your Lordship, very important aspect is this, Lordship. In fact, I have to read out the whole charge sheet to get that clear. Not only he is the important person who brought on the basis of both the accused, husband-wife duo, but there was a recipient lady. He is also an accused here, but she is not before the court. To whom it was supposed to be given. So the source from where it was to be collected, the main accused who was supposed to transfer, the collection part is done on the basis of husband and wife duo. Transportation has to be done with the main accused. Recipient has to be given to X, and the whole chain is completed. So prima facie, Lordship, it's not the case of an individual case where somebody was purchased it and was in possession. It was a case of a circuit being completed. And Lordship, elsewhere it is also submitted that both the husband and wife duo stated that they have been doing this for quite some time. And they were involved in this. And we have got two cases where they have involved. So at this stage, Your Lordship, prima facie, 37 clearly says it is a case of prima facie unless. And then Lordship is held in this para 19 of the same judgment. Lordship will kindly see there's a right position of law clearly held it. Lordship is para 19 is very important, Lordship.
Lordship has demarcated the parameter which is clearly wrong. It is reiterated the case falling under provision of section 37 NDPS that negation of bail is a rule and grant is an exception. It need not be reminded that one of the factors to be taken into account by the court while considering the question of grant bail is that court must reasonably convince that the accused is not guilty of the offence he is charged, and if he is released on bail, he shall not commit the same offence. Court has rightly held these two twin conditions, Your Lordship. Now, in these two conditions, prima facie, I just submitted. And the second part is this, Your Lordship, if released on bail, shall not commit the same offence.
This is a case of commercial quantity.
No, my lord, this is a commercial, this is intermediate. This is 91, this is 0.55 grams. This is my lord, I would like to submit. This accused Sokothang procured the drugs from Manipur, and he was arrested at Nonsling on the 15th June, and I was arrested on 18 July. So when at the time of the arrest of Sokothang, I was not present in the vehicle. I was later on arrested with an allegation that yes, but my lord, I was arrested. When the police arrested me, there was no any recovery of drugs from my possession. I have not.
Mr. Sharon, you may have been arrested. You see, when at the time when you were arrested, nothing was recovered from you. That could have been the case, but the fact remains that you have been named as the main supplier. So you have supplied the contraband at some point of time. Let's put it this way, you have handed over the said contraband to the main accused at some point of time prior to the date when you were arrested. So that's the only link, that's the only change that has to be established.
My lord, but
and that could only be done so in course of evidence, in course of the trial. So,
Lordship, can you see this part also? The chain is completed. If you read this part of the evidence, this particular accused is not before the court, but she completes the chain.
you're reading
This is a statement, Lordship. The second paragraph.
statement of.
Yes.
My lord, here in this case, I would like to submit. I would like to repeat the same submission. My lord, from my personal, no drugs was recovered, no mobile phone was recovered. My statement under section 164 not recorded. Section 67 of the NDPS, my confessional not recorded. Section 164 of the CRPC not recorded. And my lord, two prosecution witnesses has failed to depose before the court, and they have never taken my name in my cross also, in the chief also. There is no any prima facie evidence to substantiate that I am involved in this case. My lord, I cannot be harassed, I cannot be convicted simply on the ground that one of the co-accused mentioned my name during the police custody. That cannot be the sole reason to convict or to harass me. I have requested the police officer during the time of arrest that not to arrest me, as I have not done anything. But my prayer was not considered. They have mercilessly tracked away to me and my wife. From my wife also nothing was recovered. That is a different thing. So, my lord, here I am moving only for the accused Khailan Hakim. So here it is, the concrete evidence, the investigation has totally failed. During this investigation, nothing was recovered. There was no prima facie case against me to substantiate the allegation made by the police. So, my lord, when there is no recovery of drugs, the question of section 21B does not arise. When there is no recovery of mobile phone from my possession, criminal conspiracy does not arise. This is simply a false allegation against me by the police. And the evidence also, so far this evidence states nothing is there to prove against me by the prosecution. My lord, I approach before this honorable court. I have 4 children who are all minors. They are struggling to themselves for survival. In the recent flood, my house has been damaged. So my children are scattered here and there, begging here and there. So my lord, I may be kindly allowed to go on bail on any terms and conditions, and I shall always appear before the court.
So all the parties are passing the orders.
Much obliged. Good day, my lord.
Second case, same.
Same case.
So to sit in the same bench now.
Much obliged. Much obliged.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item 7, Your Lordship. Your Lordship, I'm praying for 3 weeks' time. I'm not ready, Your Lordship.
On pre-made by the appellant seeking accommodation. That is adjourned as prayed for. This is matter of 3 weeks.
Deeply obliged, Your Lordship.
Yeah, please, Your Lordship. I beg to mention item number 5.
5.
I pray for 2 weeks' time.
On pre-made by the appellant, this is matter of 2 weeks.
Daily list item number 1.
May I please, Your Lordship? This is an appeal against the judgment and order oral dated 23/8/2024. The main fact of the case is that I was appointed as a Gambura of Borshibanda and Goladegli Part 2, my lord, on the 23rd March 2016, my lord. Page number 49, my lord.
Yes.
Shall I read out, my lord? In pursuance of the office notification dated such and that 15 March 2016, the Executive Committee of the Garhwal Autonomous District Council, Tura, is pleased to appoint Sri Abdul Manaf, son of Mohiruddin Sheikh of Borshibanda village, P.O. Bularvita, District West Garhwal District, Fulbari, to the post of Gambura of Borshibanda and Goladegli Part 2 village, my lord. Then, my lord, what happened? Now I am coming to the how the appointment of the Gambura was made. As per the executive instruction, my lord, Rule 162A, my lord. And the only I will see the factor is required for appointment of the Gambura. The following factors shall be taken into consideration. Number 1, the claim of the family of the Gambura, then views of the Mojadar, the suitability of the person for the post, my lord. And the Gambura is treated as a Gambura shall be entitled to the protection provided under Article 311 of the Constitution of India, my lord. Then I come to the next page, my lord, ruling. The appointment of Gambura is to be made under Assam Land and Revenue Manual, Volume 1, Part 8, Chapter 8, subject to executive instruction contained in Rule 162A to 162D. The executive authorities or the appointing authorities have possessed no unbridled or arbitrary or unguided power to decide the case of Gambura, but only they must decide the same in the light of criteria or fact of the case, which is the dominant and guiding spirit of the aforesaid executive instruction, my lord.
Why are you reading all this? Why are you reading? What is,
There is this ruling, my lord.
what is your case? You have been dismissed as Gaupura?
62C
Yes,
D.
Mr. Hajeka, you have been dismissed as Gaupura.
No, yes, I have removed from the Gambura of Goradigli Part 2, my lord. I have removed.
You have removed or been removed or was removed
No,
or will be removed.
no, I have appointed the Gambura for Borshibanda and Goradigli Part 2, my lord. And they have removed me from the Goradigli Part 2 village, my lord, by bifurcating it and appointing another person, my lord.
Yes, please continue.
Yes. Thereafter, my lord, what happened when I came to know from some reliable sources that some few vested interested persons are trying to make a complaint for bifurcation of my villages, my lord. Then I have submitted a representation, my lord, on 19/12/2023 in an excerpt for page number 51, my lord. Yes. Here, my lord, here, this is the most important, my lord. To the Secretary, Garuhil Autonomous District Council, Tura, West Garuhil, dated 19 December 2013, unjustified claim of bifurcation of Gaumburaship, Borshibanda and Goladegli, Part 2 thereof. Respected sir, in continuation of the above subject, I have the honor to converse the following few lines for your consideration and empathetic order. That sir, I, Sri Abdul Manab Gambura of Borshibanda, Goladegli, Part 2 village, since 23rd March 2016, White Office Order number such and such, dated 23rd March 2016. Dear sir, Goladegli Part 2 village is an adjacent village of the Borshibanda and moreover a Goladegli Part 2 village having a very less number of household which can be well maintained by one Gambura, my lord. Next para, my lord. That's are from a defendable source, my lord. When he came to know, able to know that some self-interested persons are demanding unjustified bifurcation of Gaumburaship for Goladegli Part 2 village, which is totally unfounded because Goladegli Part 2 and Borshibanda village is the same village, only the name people are tell apart, my lord. That's another fact is that the Syed Hossain is also the Gambura of Vlarvita, Borshibanda and Goladegli Part 2 village, White Order such and such, dated since long time we both are friendly looking and solving all the problem of three villages, Borshibanda and Vlarvita and Goladegli Part 2. Beside, we both the Gambura are not giving any no objection certificate for the bifurcation of the proposal of Goladegli Part 2 Gaumburaship. Further, the Borshibanda village is not a revenue village in this state of affairs. Now it would be possible to bifurcate the Gaumburaship of two villages, that is Borshibanda and Goladegli Part 2. In this respect, I would like to request to the authority kindly nosedive all the self-interested and baseless demand. I will be grateful to you forever, my lord. Here, when he come to know that somebody are trying to bifurcate and submitting some false allegation against him, then he submitted this representation not to entertain the false allegation, my lord. Next, I am coming to page number 63, my lord. Shall I read it, my lord? Proceeding for general meeting of the village Goladegli Part 2 for the selection of Gambura headman held on 10th August 2023 at 11 a.m. under the chairmanship of Ikramul Qazi, son of Abdul Kader Qazi, in the premises of Mubarak Ali. In the meeting, it has been discussed thoroughly among the members and villagers present. The meeting, a resident of Galadigli Part 2, Mr. Mohbul Sheikh, son of late Abdul Jalil Sheikh, has been selected by raising hand of majority member present there to make him as a Gambura of the aforesaid village, namely Galadigli Part 2 village. The meeting has then requested Mohbul Sheikh to submit the resolution to the concerned Garhwal District Council, Tura, for its early approval and necessary action, my lord.
See, Mr. Hajara, you tell us what is your case.
Now I am coming to that. My case is that, my lord, because this resolution cannot be taken by anyone else, my lord.
What resolution?
There is 200.
resolution?
Yes.
What resolution?
No, that public meeting held, and this resolution they
Where
have
is the resolution?
that general public meeting held by the respondent number 5, my lord.
Which page?
Page number 63, my lord.
This is the resolution.
Yes, my lord.
Okay.
And here, my lord, what happened? They have put the signature of around more than 200, my lord. 90% are from the other villages, my lord. Only 10%. Then I am coming to the another.
This is a meeting for selection of the Gaubura.
Gambura, my lord. But it is out of the law.
Gaubura of
Galadigli Part 2 village.
Of the village where you are the head.
A Gambura, existing Gambura, my lord.
Okay. So it is a parallel
yes,
meeting.
Yes.
No,
Yes.
no, my lord. That is not the case.
It is a permanent village, my lord. I am permanently.
I'm talking about. See, in the same village, you say that you are the headman of that village.
Yes.
By this page 63,
Yes.
they have selected somebody as the Gambura in your place.
In my place, my lord.
That is your.
Yes, yes. And there is.
You are aggrieved by that action.
Yes. And then another order, my lord. On this basis, my lord, they have passed some into impugn order, my lord. After that,
Who has passed?
I am coming to that point.
Who has passed the impugn order?
Yes, that in Annexure 85, my lord.
Page?
85. Page 85. That is in the Garo. Then 86 is the translate copy, my lord. Here my grievances is also here, my lord. After that resolution they have submitted, they come for a spot inquiry, my lord, without serving any notice to the general public, and I am being the existing Gambura, I must have received a notice for the inquiry, but they have not given any notice to me. I do not know regarding this inquiry also, my lord. I read out this inquiry, how this inquiry. Inquiry report in writing. Sir, with due respect and by abiding the office order such and such dated such and such on 7/11/2020 had done the spot inquiry, my lord. What is it? At the time of inquiry, many people are creating chaotic drama, argued, but we resolved the situation and started inquiry. The supporter of Borshibanda Gambura is run away. So therefore we could not take the statement of President Gambura, but we could see that most of the people did not like Abdul Manna because at the time of need he always shows the attitude. It is true that the people of Borshibanda has run away. Therefore we had asked the people of Galadigli Part 2 that they gonna stay under the Borshibanda Gambura or not. We had even asked whether they need a new Gambura or not. In reply the question, they replied that they need a new Gambura for the Galadigli Part 2 village. So therefore, sir, we are requesting you to divide or to do the partition or segregation of the said area of the Galadigli Part 2, my lord. Here, my lord, when any inquiry, I am being a government servant and it is going against me, inquiry is conducted, they must issue notice to me, my lord. And moreover, there is no specific law that bifurcation can be done by the district council, my lord. In pursuance of these things, my lord, they have passed another illegal order, my lord, in page number 89, my lord. Here we will this thing, my lord. Given the wrong wording, my lord. Order. The case record put up today, the case was come to this authority as one Mohibul Sheikh has filed an application for the appointment of Gambura of village part 2 by bifurcating from the present Borshibanda village. So any individual cannot do it, my lord, because as per the law, they have to take the decision of the family members of the existing Gambura, Mojida report, views of the villagers, and suitability of the person, my lord. The petitioner is the candidate to appoint the post of appointment of Gambura of Goradigli village, bifurcating present Gambura of Borshibanda village. The petitioner stated that the Goradigli part 2 is one of the biggest and having huge number of population which is administered by the Borshibanda Gambura. And as such, it is very difficult to manage the day-to-day affairs of the villagers, and also the people of Goradigli part 2 is facing serious difficulties and hardship to obtain any certificate or verification from the present Gambura of the Borshibanda village. This is a totally false allegation they have made, my lord. Therefore, the petitioner prayed that in the interest of the people of Goradigli part 2, new Gambura area may be created from the village of Borshibanda and appoint a new Gambura, bifurcating the village of Borshibanda, which shall consist of 4 more villages, which are Batilda, Bindabari, Shahadodoba, and Nodapoti. Opposite party Sri Abdul Mannaf has also filed a written statement objecting the creation of new Gambura area, Goradigli part 2, by bifurcating the present Gambura of Borshibanda, my lord. Here, my lord, what happened? I have never participated, only I have submitted that representation. That representation time they are asking to file a Hajira, revenue officer. Along with this thing, I have filed a Hajira only.
What is your case before the...
No, I am coming to that, my lord. Yes.
Tell us, what is your case?
That before this single bench, my case is that as Gambura is treated as a government servant and protected under Article 311(2), my lord, so he should give a reasonable opportunity of being heard before passing the impugned order, dated 24/4/2024, for bifurcating my existing village. And the single judge stack it little different way. His contention is that, the single judge contention is that he is still a Gambura, but I have been so the Article 311 is not applied, because here, my lord, I am the Gambura of Borshibanda and Goradigli part 2. When bifurcating my Gambura-ship from one part, that is removed. It is removed from me from the Goradigli part 2 village. So Article 311 is applied. And moreover, the district council cannot show that they have issued any notice to me. And they have alleged that I have given a written statement. I have never given any written statement, my lord, before this single judge.
Yes, so who's the respondent here?
I am for the district council, my lord. The allegation which has been leveled by my learned senior is totally false, my lord. My lord, may kindly see the affidavit that we have filed in the writ petition, my lord.
Any other respondent?
Yeah, private respondent is there, my lord.
Who is this private respondent?
Is the present Gambura, my lord. Present Gambura. But the case which has been projected by my learned senior, my lord, is half truth he has spoken before this honorable court. It was for the bifurcation of the village. There was 2 villages, he was heading 2 villages as a Gambura. District council, my lord, there is a policy making decision of the district council, my lord. If there is a need or demand from a village, my lord, that we want to have a different village, my lord. The Gambura, the present Gambura has no saying, my lord. First thing, my lord. So it is a policy making decision of the district council that we want to give a different Gura because there was a requirement or there is a need so that the administration or for the collection of the land revenue of the district council, my lord, they can assist. My lord, may kindly come to page 58. That is the affidavit that I filed before the learned single judge.
Page 58.
57, my lord. 57, para 7, my lord. That is the affidavit that I have filed, my lord.
Anyway, since there is also another respondent who is not present today.
Let notice be issued.
No, notice I will issue. Notice may be issued to the private respondent. And moreover, private respondent has not filed any affidavit also.
Come to page 86.
What is the law which guides bifurcation, Mr. De?
There is no such law, my lord, for the bifurcation of the
Then what
village.
situation
Is a need of the. If my lord may kindly see the regulation, my lord, Assam Land and Revenue Regulation, they say three things has to be considered, my lord.
What?
For appointment of the Gabura.
We are not concerned.
No, I'm coming to
we
that.
We are not concerned with. See, here the question of bifurcation.
My lord, that is what I'm coming.
Just tell us.
Yes.
At what situation you can bifurcate a village?
If there is a demand, my lord, if there is a need.
Where is that?
That application says, my lord.
There is a demand just because
my lord,
some section of people loses confidence on the elected person. Can you divide the village and give one part to another leader? Can you do it?
My lord may kindly see the conduct of the petitioner before that, my lord. Now, if my lord may kindly come.
You should have removed him if there is a problem which is conduct. How can you bifurcate? Now what happens in the bifurcated person? If there is any dispute, then again you'll bifurcate that part.
No, it's dependent on the number of villages, my lord.
This is not something correct. Your approach is not very correct, Mr. No, see your inquiry report. It says that some people they have lost confidence in the petitioner.
Yes, my lord.
That is why you bifurcate the village and you give charge to somebody else.
My lord may kindly imagine, my lord. There are two portions, my lord, two different parts, my lord, like Police Bazaar and GS Road, my lord. Now GS Road people are not happy with him, my lord. They have written to us.
Yes.
We conducted a spot inquiry. He created a problem in the inquiry, my lord.
Can it be reason for bifurcation?
No, that was not the reason. That was not the only consideration, my lord. Because there was a request made by the villagers, my lord.
See, villagers requested basically because that's like even your record says, that order says that some people have difficulty in getting certificate from the petitioner.
Yes,
writ petitioner.
My lord.
Or the appellant hearing.
My lord, my lord.
So can it be a reason for bifurcating village?
No, that is not the only reason, my lord. That is not only the reason that because of that, my lord.
See your report.
My lord may kindly see.
See your report at page 86. What does it say?
My lord may kindly see page 87, my lord. I will come to that.
No, you first say this is your report, isn't it?
Yes, my lord.
This is the inquiry report by you.
Because the entire file was placed before the learned single judge, my lord. The learned single judge has gone through the record.
See, each and every time if a dispute arises, or if there is a loss of confidence on the leader by some section of people, you'll go on dividing the village.
It's not
what kind of solution is this?
No, we are not dividing the village, my lord. There was a need for division of the village. It is not the village which has been divided. Two part has been segregated only, my lord. Two village, he was running the administration of two village, my lord. We have taken away only one part of the village where the demand was made. It is for the welfare of the villagers, my lord. If the villagers are not happy with him, my lord, how can we force him to be the...
He was heading
two villages, my lord. My lord may kindly see the appointment letter.
Yes.
So there are two villages already in existence?
Yes, my lord. There are still two villages, my lord. And he still remain as a headman of one government.
Before his appointment...
Was for two villages.
Before his appointment in 2016?
My lord.
Who was there and for how many villages?
For these two villages. Three villages was there.
Just because some people they lose confidence Can you? And if you say if that is the reason, then you have to give an opportunity to show cause.
Now, whether we have given or not, my lord, that reflects on my affidavit. We have given him an opportunity. He has filed an hazira. Now he comes and says, my lord, the hazira was for representation. Can you believe, my lord, for a representation, a district council will ask an hazira, my lord? We have a record, my lord. We'll place the record before this honorable court. What was the case he has projected first, my lord, that he has been removed from governance?
We see single judge has not taken this aspect of the matter at all. In his
And we'll admit the appeal.
Yes.
Heard Mr. Sajjarika. Then a counsel to the appellant. On consideration of the submission made, the appeal is hereby admitted. Mr. S.D. Leonard, Standing Counsel, JHDC, appearing respondent 1.
Oh, yes, respondent number 5, my lord.
You are
I am for respondent 1 to 4, my lord.
respondent 1 to 4. Is in attendance before this court, and as such, no notice is required to be issued upon the said respondent. However, the appellant is directed to take steps for issue of notice upon the respondent number 5. The same returnable within 2 weeks. This is matter thereafter.
Item number 3.
My
lord, in this case, I am appearing for the respondent number 2 to 6, my lord.
Yes. Yes, Mr. Singh.
My lord, we have filed our affidavit in opposition against the additional affidavit of the appellant, my lord, yesterday, my lord. So, a date may be fixed for disposal, my lord.
Additional affidavit and then affidavit in opposition against additional affidavit.
No, what happened actually, my lord, I filed an affidavit showing in the similar circumstances, they have taken a different stand. Similar, absolutely same fact. Seeing this, sir, my lord, he filed an affidavit now, yesterday, he is saying, my lord.
Was there an affidavit prepared for bringing it into the notice of the court?
Is there any...
The appellant has brought the new thing, my lord, so we have to give our objection, my lord.
This interim order passed on 13/5/24, my lord. And date, my lord, may be fixed in the coming days. If it suits, my lord.
What new facts?
My lord, if it's not inconvenient, can it be done on 1st of November, my lord? It's Tuesday, my lord. If it's not inconvenient, your lordship, my lord.
So you have filed the response only today, Mr. Singh?
Yes, my lord.
Yes, my lord. I have filed my response to the additional affidavit filed by the appellant, bringing new facts, my lord.
Mr. You are BK Singh?
Yes, my lord.
Mr. BK Singh, letter counsel for the respondent number 2 to 6, my lord.
2 to 6, my lord.
Has submitted that an affidavit in response to the additional affidavit filed by the appellant, wherein new facts have been brought into the case, has been filed today. The letter counsel for the appellant has acknowledged receipt of the same. Accordingly, on prayer made, matter is posted for hearing after 2 weeks. You want a specific date or?
2nd November, 1st November, my lord, Tuesday. Is it possible, my lord? If it's not inconvenient, my lord.
Tuesday?
Tuesday, yes.
It is Friday. I think it may be closed because of the holiday, my lord, Diwali holiday, 1st of November, my lord. There may be a holiday, my lord.
No, I have seen that calendar. Somebody showed me, my Lord Lordships, this High Court's calendar. I found it.
No, it's a working day.
It's working day, my Lord. Yes.
Oh, okay, my lord. Okay, my lord.
Oh,
I have seen that, my Lord.
working day.
This is working day, yes.
My
Yes,
lord.
here it is
Okay,
working.
my lord.
As prayed for by the parties, this is better on 1st.
And it may come in the admission column, my Lord. An endeavor shall be made, my Lord, to dispose of. A small issue, actually.
Yes,
Very
yes.
small issue.
It has not been admitted.
Not admitted, my Lord. Your Lordship may admit and fix this on second, first.
Only given.
My lord may admit the appellant appeal, my lord.
Yes, yes, and fix then on 1st of November, my Lord. Yes.
Appeal admitted. So I get to give you more. This is matter for hearing on 1st.
This is interim order that may continue, my Lord. Interim order is there.
Is there any?
Yes, yes.
What is the interim order?
Yes. 13th of May 2014, my Lord. Your Lordship sitting with Honorable Chief Justice grants this interim order, my Lord.
You can't expect me to remember each and everything.
That's true, that's true. 13/5/24. No coercive action shall be taken against the
As prayed for by learned counsel for the appellant. In view of this court's order dated 13/5/2024, the interim protection given will continue until the next date fix.
Obliged.
Obliged, my lord.
Item number 4.
Lord, item number 4, the argument was concluded. My Lord, the written argument, yes, my Lord, this is reflected in the order itself.
I'll give short reply, Your Lordship, very
My
short.
Lord, today,
Very short.
it's not fixed for argument, my Lord. Today we have to file the written argument, my Lord. My written argument is ready, my Lord. I'll file it in the course of the day.
My Lord, I'll just seek the leave of this court, my Lord. Just 10 minutes, Your Lordship. Some points only I'll clarify, my Lord. This cannot be put into, my Lord. One judgment is there, and just I won't take more than 10 minutes. Your Lordship, I can always seek the leave of the courts and point out certain facts, Your Lordships. I'll make it very brief, my Lord.
If you bring out something new,
No, sir, not something. No.
Kindly allow the court to put it.
Lordship.
Do not get agitated. Court is not saying anything against you.
No, sorry.
If you raise something new, if you need some decisions, definitely they will have a right to at least respond.
Yes, they will have, my Lord. Because
Now-
what he
now
submitted.
If Mr. Bhattacharya is filing today is written response.
Lordship.
First of all, if you advance some moral argument, how he will respond to it?
No, my Lord, that's what I'm saying, my Lord. I'll just, my Lord, I'm not going some clarification with respect to what he has submitted. Certain clarification, my Lord. I'll make it very brief, my Lord.
My Lord,
If Your Lordship permits me.
due respect, my Lord, the clarification was already given on the previous date, my
No,
Lord.
my Lord, I have never submitted after that.
My Lord, he had made his submission, my Lord. Thereafter,
But I'm seeking the leave of this court, my Lord. Can he stop? It's up to Your Lordships. If Your Lordship wants me 10 minutes time, Your Lordship. Just,
He can respond.
yes, definitely, my Lord. I'll not stop.
My Lord, the order was very clear. my
Yes,
Lord.
orders, but then if
I'm seeking the leave, Your Lordships. My Lord, 10 minutes time, my Lord. Just 10 minutes time. Now, my Lord, this is a review application, Your Lordships. My Lord. Review application, my Lord, seeking the review of the judgment, my Lord. Only on the one ground, my Lord. The core issue, my Lord. There were two issues raised, my Lord, before the bench, before the single bench. One is, my Lord, my entitlement. I will not go into it. Court said, yes, you are entitled. But delay and laches. Because my placement was made by an order dated, my Lord, 1/12/2014. 1/12/2014, Your Lordships. So any cause of action arises thereafter, not before that. 1/12/2014. So admittedly, I filed the writ petition, my Lord, in the month of June 2022. I filed, my Lord. So by an arithmetical calculation, my Lord, 8 years. Now, 8 years is a long time, Your Lordships. In between, what happened, Your Lordships? On August 24th, 2020, I filed several representations. Ultimately, my representations were answered, and the Director of Higher and Technical Education acknowledged our rights. That was a communication made by the Director of Higher and Technical Education. Acknowledged my rights, Your Lordships. Now, here the single bench, single bench, my Lord, looked into it, but there is no categorical finding. But single bench simply held that there is a delay and laches and dismissed the case. Now, my sole contention before the division bench, my Lord, that these documents should have been taken into consideration. There is no delay and laches. One, my Lord, on 24th August 2020, my Lord, this communication was made. This is followed by a representation, my Lord. Representation was made on 21st June my lord, 2021. And thereafter I came to the court. Now, my lord, writ petition, as I said, my lord, there is no condemnation, limitation will apply. Had I come within a reasonable time, my humble submission, this is very reasonable time I came. So that is the issue I had taken before the learned single judge, before the division bench. That is the core issue, my lord. Entire thing depended on. Now, my lord, as I had pointed out, your lordship, I will not repeat, the judgment of the division bench, my lord, this aspect was not taken into consideration. Not taken into consideration. This was not within the notice. Somehow escaped the notice. Now, what the division bench, my lord, discussed in 2 paragraphs, my lord, this is 3-page judgment, my lord. 2-page, my lord, the reproduction from the single bench, my lord, and 1 finding. Now, there are 2 findings, my lord. 1 finding, yes, there is a delay of, even filing the representation, there was a delay of 8 years. I cannot answer, my lord, how can it be 8 years, my lord? If we count from 2014, I filed the representation has been quoted in the judgment, your lordship, 2020. It can be 6 years, my lord. It cannot be 8 years. But anyway, my lord, those things will come if your lordship allows this review petition. So, my lord, these aspects was not even remotely touched. Had it been remotely touched, my lord, I would not have filed this review petition. Had the judgment said that we have looked into the findings and we do not interfere, that would have been enough, my lord. I would not say that judgment would have cited the reasons, not required. But that was not within the notice of the court while deliberating the judgment, my lord. So, my humble submission, this is an error apparent on the face of the records. Now, my lord, if your lordship, what my learned friend said, that I have said all throughout erroneous judgment, I never said it is an erroneous judgment. If you kindly, my lords, look into the grounds in my review petition, first ground, my lord, that is very clear. A. For that there is an error apparent on the face of the record, inasmuch as the Honourable Court, while proceeding to appeal by judgment and order, it has not taken into consideration the acknowledged made by the Joint and Higher Technical Addition in its communication dated 24/8/20 with regard to the entitlement of the writ petition review petitioners, additional placement, academic grade pay. Now, this is good enough. I have repeated virtually the same thing. So, what my learned friend last time was repeatedly pointed out, that in my ground, I have said the judgment is erroneous because the law is very clear. I have placed one last judgment. Law is very clear. If the judgment is erroneous, you cannot seek a review. If there is error apparent on the face of the records, only that. So, this is an error apparent on the face of the record, not even remotely touched. What the division bench did, my lord, simply, my lord, referred to paragraph 10 of the learned single bench. Now, again, I have gone through paragraph 10. That paragraph 10 of the learned single judge judgment, there was no reference of this acknowledgement letter dated 24th August 2022. Well, that was only with regard to delay and latches. So that was referred to, my lord, and the judgment produced, my lord, has been relied on, and it was dismissed. So, my lord, my humble submission, my lord, the grounds I have categorically stated, this is an error apparent on the face of the records. So, my lord, this is a case, my lord, which called for review. Now, my lord, I'm sorry, that day I could not produce, my lord, very recent judgment. What is error apparent on the face of the records? They have clarified. I have given a list of books, my lord. 2023, 8 SSE, page 11. Para, my lord, 29 to 45. These are short paragraphs, my lord. Para 29 to 45. Briefly. 28. I start. A 3-judge bench of this court, as your lordship got it, my lord.
Yes.
A 3-judge bench of the court, comprising of justice such and such, in such and such case, discuss the scope of the phrase error apparent on the face of records. The challenge before this court in the said case was the judgment of the High Court on the ground whether it suffers from an error apparent on the face of the record. The High Court had issued a writ of certiorari and had quashed the order of the tribunal and restored that Mamlatdar. In para 8 of the report, the issue which was to be considered is reflected. The same is reproduced. Para 8. The main question that arises for our consideration in this appeal by special leave granted by this court is whether there is any error apparent on the face of the record so as to enable the superior court to call for the records and quash the order by writ of certiorari, or whether the error, if any, was a mere error not so apparent on the face of the record, which can only be corrected by an appeal if an appeal lies at all. 30. After discussing the relevant material on record and conclusion, is stated in para 17 the report, the view was that where an error which has to be established by long drawn process of reasoning on the points, where there may be conceivably two opinions, can hardly be said to be an error apparent on the face of the records. The view that long drawn process of argument to canvass a point attacking the order of review jurisdiction cannot be said to be an error apparent of the face of the record. So they have laid down the task, my lord. Now here is the case, my lord. Do we need, my lord? 24/8, not even remotely touched. It was not within the notice of the courts. But that makes a lot of difference. That is another thing. If this point was argued negative, that would have been a different thing. This was not within the notice of this courts, nowhere, not even remotely referred to, my lord. So this is an error apparent on the face of the record. Then I will take my lord to relevant paragraph 31. Another case which may briefly dealt with such and such, where this court ruled that under Order 47 Rule 1 CPC, a judgment may be open to review inter alia if there is a mistake or an judgment or an error apparent on the face of the record. An error which is not self-evident and has to be detected by process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review. It also observed that the review petition cannot be allowed to be treated as an appeal in error. My lord, is it not self-evident, your lordships? Because my whole case is on that latter. Not even discussed, my lord. Not even referred to. Not within the mind of the courts. This is self-evident. Now, your lordships, I will take to paragraph 35. From the above, it is evident that the power to review cannot be exercised as an appellate power and has to be strictly confined to the scope and ambit of Order 47 Rule 1 CPC. An error on the face of the record must be such an error which mere looking at the record should strike and should not require any long-drawn process. Same
in different
way. Now, my lord, what I am saying, your lordships, here admittedly, my lord, court of action, my lord, admittedly going by the pleadings I made, on December, my lord, when the placement was made. Placement was made by a letter dated 1st December 2014. And my lord, ultimately my representation, my lord, this is very important, was answered and our rights were acknowledged by this letter dated, my lord, Director of Higher and Technical Education, dated, my lord, 24th August 2020. Look, my right has been acknowledged. You know, here, my lord, I'll just point out one thing, your lordship. Even in the Limitation Act's money claim, the period of limitation 3 years. But before the expiry of 3 years, if an acknowledgement made, fresh period will start. So here my right has been acknowledged by that letter. And thereafter I filed a representation. There is no reference of that representation either by the single judge and even, my lord, before the division bench, my lord. Though these were the issues, my lord, repeatedly I argued, my lord, in my pleadings. These were not referred to. So, my lord, without going into this, my lord, the issue could not have been decided. Now, other thing the division bench has said, not continuous wrong. Now, what is the letter dated 24th August 2020? It says, I am entitled to the increments as per the UGC regulation of 2010. If I am entitled, my lord, it is a continuous wrong. So what the other finding that is not a continuous wrong, my lord, will depend on the, my lord, decision to be taken by this honorable court on the letter dated 24/8/2020. So my humble submission, my lord, it is self-evident, my lord. There is no question of two opinion. So this is a, my lord, classic case, my lord, which needs to be, my lord, reviewed, and lordship will restore this case to file, my lord, and hear us. Well, that's
drawing analogy
lordship
of limitation by taking into consideration money suit.
No, my lord, I'm just
in this case. Is it proper? How, which way?
No, my lord, what I am saying, my lord, there is an acknowledgement of a right.
See, in a money suit, acknowledgement is different. It is a person who is to receive money from you, or who is to, who is to pay to you, acknowledges. Here it is not. Here the letter of the authority, basing on which you are saying that your claim was basically acknowledged, not correct. Then why that person should have himself taken the decision? It is not that. He was not the decision-taking authority.
Lordship, I am coming to it.
Just let us just finish.
Lordship.
So can his communication, which apparently you say in your favor, be treated as an acknowledgement of your claim by the by the respondent?
Lordship. No, my lord, exactly what your lordship has said, that was good. This is a letter, my lord, I will not read it again. This is
Do not come to the letter. We are talking about these things. You have drawn analogy of money suit.
My lord.
Do not go to the date of the letter now. Lordship. Not on the question of limitation.
Lordship.
The question is that the letter, which apparently you are trying to interpret as in your favor, can it be taken as a letter of acknowledgement of your claim by these things? Because he is no authority. If
that is what I want to
he was the authorities to it, then he could have taken the decision in favor of himself. So it appears he was not. He was only a forwarding. Now his acknowledgement doesn't revive the cause of action. You cannot compare it with money suit.
Well, if we can answer your lordship. Now, there is a letter. Now, this letter, my lord, this is their argument. This is an individual opinion. Now, lordship will look into my lord, the contents of the letter. They say very categorically, after examining everything, say this is the opinion of the Director of Higher and Technical Education. Opinion of Director and Higher and Technical Education. And they ask the government, do accordingly. Now, this is with regard to my entitlement. Now, so far, regarding my entitlement, with reference to the rules, regulations, schemes, decision, a long argument was made. So far, my entitlement, this is not rejected by the single bench. Single bench also, my lord, acknowledge that I have a right.
No, just confined to the issue. You are going, we can understand. You may say that, we are not saying that, you do not have a case on merits.
Lordship.
The question was of limitation. The rejection of your claim by single bench was on the basis of limitation, delay. 12 years delay, single bench change. The division bench said the 8 years delay.
Both are not correct.
Now, according to you, that both those observations were made without looking into the very document, which is the basically crux of the issue. Now, that is why you are seeking review. We understand. But then, if you, while you argue, forwarding your argument, you have taken a stand that, like if there is an acknowledgement, then even the limitation prescribed in the money suit of the period of 3 years, that gets revived. That is a settled law.
No.
The question which this court is putting to you right now is that the letter, the base of your claim, can it be termed as an acknowledgement?
Well, I will not say. I will withdraw that. It's not an acknowledgement, but
I will not. Why this question comes is
not sure I understand.
It could have been had he be the deciding authority. If it was the case that his finding would be the final finding with regard to your claim, we could have said that okay, any kind of indication by him could have been. But then here it seems he's the only forwarding authority, recommending authority. Now, how far binding his recommendation would be on the appropriate authority, so long there is no such law.
Regarding the official communications, these I have cited anyway. These were not referred to the single man. Regarding official communications and decision by an authority, no doubt he is Director of Higher and Technical Education, is an authority of the state, my lord. That cannot be refused. He is an authority. Now, when a communication has been made, making certain, my lord, conveying certain opinion or decision, your lordships. Now, my lord, law is very clear. By an affidavit, by making a submission, your lordships, that cannot be altered. And this has been way back laid down, my lord.
There is no doubt about that. There are
decisions.
There
So,
are
my lord,
decisions.
my lord.
You see, the grounds raised in the affidavit cannot override the grounds which is there in the impugned order, or which appears.
Yes, my
That is settled. There is no dispute with these things. But then here, probably that is not a thing. Probably you have not. The court is unable to put the query, or probably you see, like there is probably seems like a gap. We are not on those issues.
No, sure. And
Only
so
thing is that part when you say that the acknowledgement and revival of cause.
anyway, my lord, I will not use the word acknowledgement. I want to say, your lordship,
that is
the Director of Higher and Technical Education said yes, they are entitled. Now that communication was sent to the Secretary Education.
That is okay. He may say yes, but then that yes has no finality so far as this matter is concerned. The controversy is concerned.
My lord, my humble submission.
But then see, so if it doesn't have any kind of finality, then in such a case, can it be said as an acknowledgement?
Well, how
That
it
is
is?
the question. This court is not saying anything against you, but then
No,
if
no,
there
I'm
is
not-
any such law, if you can please us, because like to the understanding, the best of understanding of this court, at least myself, not
My lord,
my lord, these
my
things, that acknowledgement is something there. You see, where the admission is unambiguous,
No, sure.
it's clear.
No, sure.
Then only you can say yes, it requires. We agree on that.
No, sure. Now, here your lordship will appreciate, my lord, this appointment of lecturer and another thing, my lord. The approving authority is the director of higher and technical education. They are the controlling authority. Now, controlling authority is saying we are entitled. We are entitled. I'm not saying acknowledge. We are entitled. Finding of the learned single judge is, as per law, we are entitled. Now, here, why I am heavily relying on these judgments? The DHT, my lord, Director of Higher Technical Education, my lord, they conveyed their decision, my lord, only in August 2020. This matter was pending. This matter was pending with them, and ultimately they had taken a decision and wrote to the, my lord, Education Secretary to do the needful. Now, this is a document, my lord, could not have been ignored. It could not have been said, my lord, this opinion is an individual opinion. This is not an individual opinion, my lord. This is the decision of the Director of Higher Technical Education, my lord, who are the, my lord, in this case, our employer. Now, our employer said we are entitled. Single judge, my lord, went into the different aspect of the law, said entitled. Now, the only thing remained, my lord, limitations. Now, when this letter comes, your lordships, that means the issue was, my lord, pending before the Director of Higher and Technical Education. And it is not the case. If they had said, my lord, they had nowhere said, my lord, this is something not binding. They said this is an individual opinion, but this is not an individual opinion.
That is indirect saying. Without saying directly.
No, my lord, it cannot be. When some document is placed before the court, your lordships, my lord, certain decision has been taken clearly, categorically. That could not have been diluted even filing by an affidavit and making a submission.
That would have been binding on them.
Lordship. Yes.
Binding it
yes,
is a binding force.
Yes, it's a binding force.
Where is the law?
I'll say it, my lord. That's once your lordship. That's why.
No.
That is relevant because these issues. That's.
If you say then definitely your contention with regard to the revival of cause of action will stand. If you say that is the law.
That is the law.
So if you say that the forwarding authorities or the controlling officers' recommendation will create a binding force on the deciding authority of the government.
Yes.
Where is the law?
This, well,
not in every,
what lordship? These I should be given an opportunity, my lord, to argue this point because this point was not taken into consideration by the division bench.
See whether it should be given or not. That is.
No, this is now we are in the review, your lordships. Only in the review. So review unless because this is something, my lord, a decision taken by Director of Higher and Technical Education. This just cannot be wished away like this.
You are saying somewhere beyond, Mr. Sen, not confined.
My lord, I am confined. My only prayer here before this, my lord, court in this review petition. Only in this review petition is this. This is the issue, my lord. Now, whether it is having a binding force, that comes when your lordship restored this appeal. Lordship here, my lord, recall this order, my lord, restore this appeal. Only then that question, is it binding? Is it not binding? I could have placed some decision. Maybe I am wrong, that's a different thing. But in the review petition, my lord, this is not even touched.
We have heard your submission.
Lordship.
What we will do is we will go through the records,
Lordship.
consider your submission, and see if there is an apparent error on the face of the record.
Yes, my lord. Because my whole case, again, I am saying, my lord, on this. Had it been discussed, and what my lords are saying that, even the court said, this is not binding, matter would have ended there, lordships. No request to go further. It has not been touched, it is not in the mind of the court. So here I need an opportunity, my lord, to argue this case.
Yes.
On this point, I need to argue this case, my lord. That's why I am praying, my lord, it need to be recalled, your lordship.
My lord, this review, in my respectful submission, my lord, is another appeal in guise of review, my lord. My lord will kindly go through the grounds. Merely stating that error apparent on the face of record will not do. What is the error apparent? You are merely relying on the representation, consideration. My lord will kindly see when is the representation? 2020. Your entitlement is in 2014. You are stating that some fact is not looked into. How it is not looked into? Matter of fact remains whether it is 6 years or 8 years or 12 years. There is a delay. There is a delay. You have approached this honorable court as a later stage. My lord, the single judge, even with regard to the representation, my lord, there is a clear observation by the learned single bench. Even with regard to the representation, how it was approached. My lord, there is an observation in that regard as well. Now, one letter, if you are saying everything is a part of record, nothing has been overlooked, that is not even relevant. My lord, the fact remains that there is a delay. You did not approach the court immediately, and the benefit which you are claiming is one-time benefit. There's a lot of financial implication is there. A lot of other factors are there, my lord.
That is a one-time benefit, not a continuous.
Not a continuing, my lord. So that is exactly why now the honorable division bench. Now, my lord, my senior has again today taken this honorable court back to the writ petition. He's again narrated the whole story of the writ petition. Then he's gone into the writ appeal, what the learned division bench ought to have done. My lord, he is clearly finding fault with the judgment of the honorable division bench. Now, again, as I've stated on the other occasion, my lord, if I am to dismiss, or the honorable court is to dismiss a petition merely on delay, my lord, is there any requirement to pass a detailed order in any other aspect? There is no requirement. Why go into this futile exercise at all? I am dismissing the petition on the petition is being dismissed on delay and laches. Where is the requirement? Why is there a requirement for the honorable court to go into all the details?
See, that we should leave that to the wisdom of the court.
Yes, my lord. So here what my senior is doing, he's challenging, in a way he's challenging the decision of the division bench. He's honorable division bench. He's also opening up the issues of the learned single bench. So all he wants is the rehearing of the whole matter. My lord, so the decision which is conclusive, which is arrived at by this honorable division bench, he is saying that no, please remove that, rehear the matter again. My lord, merely stating that there is error apparent on the face of record will not do. My lord, I am relying on, because my senior had, none of the judgments were given to me. Nevertheless, my lord, one of the judgments that I am relying on, which will be a part of my written argument also, my lord. This is of this honorable court itself, my lord. It is in the case of 7 cities, my lord. 7 cities. This is dated 8/3/2022, my lord. My lord was a part of the bench, my lord. Now, my lord, if I am allowed to read para 2 and then 6 onwards, my lord. Para 2, my lord. Then I'll rely on para 6, para 7, 8, 9. So, my lord, if my lord allows me to read para 2, my lord.
Yes.
It has become fashionable to try and take a second bite of the cherry after failing. Now, of course, this matter traveled up to Supreme Court. By way of special leave petition in the Supreme Court, review petitions are filed, apparently on the ground that there is some error apparent on the face of the record. In order to, in the order under review, but really to challenge the perceived erroneous findings. This is exactly the case. And so it has been in this case, despite counsel repeating the NOSCAM that the grounds urged reveal that there are errors apparent on the face of the order under review, merely perceived erroneous findings have been referred to over and over again. This is exactly the case here. So, my lord, I take my lord to para 6. Which is the next page, my lord, page 3. There is a distinction between the maintainability of a petition and as to whether it makes out any grounds in support thereof. A bare-bodied petition with no allegation in support of the prayer may be maintainable, but the same may fail on merits. Merely because the petition for review may be maintainable, it would not imply that the jurisdiction of review has to be metamorphosed into one of the revision or appeals to address the perceived errors of findings under the guise of there being errors apparent on the face of the order under review. Quantitatively, a review is quite distinct from an appeal or a revision. Essentially, a review may be maintained when there is some error apparent on the face of record or the order under review, or when some material which has been before the adjudicating authority was not taken into consideration, despite it having a significant bearing on the issues involved, or when despite exercise of best diligence the review petitioner could not produce some material before the adjudicating authority that would have had a bearing on the process of outcome of the adjudication, or some similar reasons that would warrant a relook into the matter. Of these principal classes of grounds, they may be invoked in course of review. The most common is the first count of there being an error apparent on the face of the order. The kind of error that can be regarded as an error within the meaning of the expression error apparent on the face of the order is a mistake which is obvious and which ordinarily is not required to be brought out with the reference to any other material, but the same is self-evident in sense that it is evident upon a plain reading of the order itself. It must also be added that the fourth class of grounds has to be seen to the adjustem generis with the three classes of grounds that precede it. In short, any or every mistake or any or every error, particularly an error in the interpretation or an error in the analysis of or perception, may not be an appropriate ground to invoke the jurisdiction of review. For completeness of the discussion, it must also be pointed out that a review, like an appeal, is a creature of statute. However, a High Court, being a court of records, has inherent jurisdiction to entertain a review petition and even to correct its own apparent mistake suo motu. When the court spells out the fact in such detail as in the order under review hearing, copiously quotes specific provisions of the statute which are relevant for adjudication and deals with several features, weigh in the court as relevant considerations, the court may still end up committing an error, whether it is erroneously applying a provision or in erroneously interpreting another provision or in committing an error of judgment in arriving at a conclusion, but such errors would not constitute grounds that can be canvassed in a review before the same forum for the matter to be revisited. Errors in findings, as in error of judgment, need to be carried for correction to a superior forum, whether in the revisional or appellate jurisdiction, depending on the scope of the revision and the extent of authority to be exercised in the appeal. Certain provisions for revision set down the parameters for assessment at such levels where the appellate provisions indicate whether appeal would be both on facts and law or purely on law. So my lord will kindly see, if there is any grievance, it has to be looked into by the higher forum, my lord. He is opening up the whole issue. Now he is resting his case on one letter. So my lord will kindly see, even that letter is not of, it is not a letter of 2014. You are pointing to the same letter. Representation is in 2020. That letter is also in 2020. What difference will it make? And he is over and again, he stressed on, my lord, that was only opinion of the joint director. It is a mere opinion, my lord. It cannot be regarded as...
We have gone through that.
Yes, my lord. So my lord will kindly see, this review petition is another appeal in guise of a review, my lord. My lord will kindly see all the grounds.
The letter which petitioner is referring, this is dated? The letter which...
That is also 2020, my lord.
2021.
24/8/20.
2024.
24/8/20.
Now, his contention is that since this 2024 has not been taken into consideration, you see this entire finding has...
That is incorrect, my lord.
Like
that is incorrect. My lord will kindly...
has come to a wrong conclusion.
No, that is absolutely incorrect, my lord.
You see, like this...
My apologies, my lord.
Why you get so impatient? See, like, do not want to face any question from the court.
No.
If court is incorrect, you have to correct the court.
Yes, my lord.
Now, let us just go by the proposition which Mr. Sen has said, assuming it is correct. The money suit, 3 years limitation, and if there is an acknowledgement after that, that revives that. Now, whether that acknowledgement has to come within the 3 years or after the 3 years, or it can be any time. Say, supposing if after the expiry of 20 years, if there is an acknowledgement, that will revive the cause of action. Is it correct?
My lord, in my respectful submission, my lord,
will not. Is it
will not, my lord. My lord, yes, my lord is correct. My lord, the representation which my learned senior is referring, it is not even 2020, it is 2021, my lord. It is a year, another year.
That is what Mr. Chan contention is basing on that. He says that this is basically a revival of his entire thing.
No, it is not, my lord. It cannot be.
You want to say that this is claim is with regard to one-time benefit?
One-time benefit, my lord.
And that...
And my lord, fact remains is that you have never made any representation. Mere verbally, my lord, stating before this honorable court that I had made several representations will not do, my lord, will not suffice. Records will have to speak. The only record which is available is, my lord, is 2020. So your mere submission will not do. Secondly, even the government letter you are saying there is another delay of another 1 year, my lord, that is 2021. So my lord, how is it helping their case, my lord? Even assuming that case, for instance, my lord, that letter is not taken into consideration. How does it change the situation, my lord? Your first representation is 2020. That too to the principal of the college, via principal of the college. So will be of no relevance, my lord. And the money suit, my lord, that case will have no relevance in this case, my lord. There cannot be any.
Anyway, before the parties.
Only a small thing, my lord. My learned friend considered one thing. This letter dated 24/8. What I am saying, acknowledgement and another thing. There is no scope in this review petition today. He is saying it will make no difference. So he admit one thing, my lord, this has not been referred to. Because had it been referred to, decided, my lord, I would not have been with this review petition. Now, what I am saying, your lordship, that should have been decided. Because the crux of the issue is this. Now, the one thing, my lord, in the course of submission before the appeal, the court could have said that no, this is not binding on the government. This is an individual opinion. But this has not been gone into, your lordship. That's the whole case is here. Now coming to, my lord, this is one-time scheme. This is we are going into merit. I'm not going. So this is a case, my lord, classic case, my lord. This is an error apparent on the face of the record, not taking into consideration. Now what is the status of this acknowledgement? This perhaps I will get an opportunity if the appeal is restored.
You are happy on
Matter
the
is hard.
same thing.
That is exactly why, my lord, my learned senior is wanting to that the appeal be reheard.
Obviously, my lord, because nothing.
My lord, when this honorable court has already dismissed this appeal on ground of delay and laches, how is that?
We are not going to that again.
Yes, my lord.
We have heard the parties.
Yes.
We will consider whether the case of the as made out by the petitioner, review petitioner,
yes, deserves
consideration or not. Simple.
Exactly, my lord, the small issue. And other thing, my lord, regarding, my lord, one-time scheme, other things, your lordship, this will not come here, your lordship. If it has, my lord, if there is a case for review, not considering this letter, which has bearing, my lord, on the core issue, it has to be recalled. Then, of course, then comes whether it is a one-time pay scheme, one-time, my lord, this is a, my lord, opinion, or this is binding, or all these issue will come then.
When
but
he
not
is
at this
submitting,
stage.
my lord, he has taken us through the whole case, my lord. Writ petition, writ appeal.
It is for this court to sift.
Yes.
Yes, my lord. This is an error apparent on the face of the record.
It is not an error.
And I have submitted, my lord, this error. It's not even remotely referred to this letter.
And
And my lord, one thing, again, my lord, cost of repetition. Even my prayer in the writ petition, act in terms of this letter. That is my major prayer, my lord, in the writ petition.
Have you filed a written argument?
Lordship.
Have you filed a written argument?
Written argument.
You're supposed to file a written argument today.
My lord.
He has filed.
My lord, I'll be filing today. But my
Who
lord,
has filed? Nobody has filed.
no, my lord, my written argument is ready. I was intending to file it today, my lord. My senior has again opened up this argument. My lord, there may be kind observation of this honorable court, my lord, that this matter will not be argued on the next date, my lord. Because again, my lord, my senior will start up, my lord,
Nothing,
saying
my
that
lord.
there
I
is
tried
some
my
more
best to
clarification,
point
my
out
lord.
not taking into consideration is an error, and which has the, my lord,
Shine is
threshold.
very fond of making argument. So whenever there is a scope, he will start.
No, but today what I wanted, I opened up that day. Today I wanted whether this is a case for review or not.
All these was
The court has duly appreciated the effort made by the parties.
No, sure.
Necessary orders shall follow. Heard Mr. Sen. This matter is posted for filing of written argument today. However, on the prayer made by Mr. S. Letter counsel for the review petitioner to allow the petitioner to bring in some new points for consideration apart from what has already been submitted. This court has accordingly heard the parties. On conclusion of the argument, the parties have once again reiterated that written argument may be allowed to be filed. Accordingly, let the written argument be filed on the next date.
Is it written argument or bullet points?
Written argument,
Bullet points.
just for
See, earlier order says brief written synopsis.
Yes, my lord. That I had actually prepared. My lord, but my lord, my learned senior has relied on 2 judgments, my lord. If he
can
give me the citation, my lord, I'll include that in my
give him.
reply also, my lord.
This is matter to 1 week.
Item number 6.
Then, my lord, I'll file within the next week.
Please.
This, my lord, this was listed again, my lord.
Actually, you should be posted for order for judgment or for orders. The order is ready,
my lord.
You have some more point of argument?
My lord, no.
As we have indicated earlier.
Yes, my lord.
Your prayer has been allowed.
My lord.
Or rather, your prayer is allowed.
My lord.
The appellant E3 is directed to be released on bail.
My lord.
If not wanted in any other cases, on his subscribing to comply with the following conditions.
My lord.
These are the usual conditions.
My lord.
Not abscond or tamper with the witnesses. Do not leave the jurisdiction of the state without the prior permission of the trial court. He shall appear in court as and when required, and that he shall bind himself on a personal bond of 50,000 with 2 sureties of like amount to the satisfaction of the trial court.
My lord. I'm deeply obliged, Lord.
Do not make him escape from the jurisdiction of the court.
My lord.
If he fails to comply with this bail condition, then
my lord.
automatically
My lord,
you
I
can
will
apply for cancellation of bail.
My lord, they will do that. My lord.
But I believe the trial should be over by the end of this year.
We're trying to finish it as soon as possible. We've completed half because the problem is that special court has got other CBI quite
commercial matters.
hectic for the trial court to complete all the trial and D2T cases also. Everything has been burdened on the trial court.
Too much burden on the
Too much. But still, we've tried to make an endeavor.
That is why you see more often than not, off the record, we, as a High Court, we don't pressurize the trial court to, to give their time. In fact, that is also what the Supreme Court has held in many occasions. You cannot put a time frame on the disposal of a case before the trial court. But we do request them to proceed expeditiously. That's the best we can do. If there are inordinate delay, unexplained delay, then that's a different thing. Thank you. Good luck. sitting
Item
in
number
BV,
10.
sitting in single. I forgot that we still have some matters left.
My lord, I must apologize. I could have mentioned in the morning, my lord. I need 1 more week time in this, my lord, to substitute.
My lord, only thing I'll point out, almost 1 year. These otherwise also, my lord, since no substitution was done, my lord, this stand abated. My lordship cannot pass any order in this case.
No, we are only on the issue of whether substitution can be made or not.
Yeah, my lord, but the time limit, my lord, is gone. Your lordship. It's almost 1 year.
Practically there was a lot of difficulty, my lord, in this because as I
see Mr. Sen,
yes,
how he changed his colors. The other case he was defending he was defending a case of delay and lashes.
My lord.
Now he's seeing
my lord.
there's delay here.
My lord, but it's all up to my lord's discretion.
No,
Because just one more chance, I will
this
do
court
it.
has given you enough
time.
only on the ground of considering the fact that the petitioner who had pursued this matter
yes, my lord,
died in the course of the proceedings.
Yes,
to that extent, indulgence was given to you to allow his
wife,
representative, legal representative to enter. Otherwise, as has been submitted. In fact, Mr. Sen has also agreed to the same. In fact, I was telling your colleague the other day.
Yes, my lord.
If the petitioner is entitled,
yes,
after everything is said and done, he
yes,
is entitled. Naturally, he will be informed. Rather, his legal heirs will be informed, and they will get the benefit.
Yes,
because I believe are they entitled to pension?
Yes, they are entitled to pension, my lord. Yes,
so some institution.
He's entitled to pension. Yes.
So in that case, everything will be calculated, according with, along with his pension. So why would you pursue the matter?
My lord, kindly give him just 1 week time, my lord. I will take a concrete stand because the problem for me is, as I've said before, after he became paralyzed, his grandson was only point of contact for me. So the grandson got married and settled somewhere else, my lord. Now,
You don't have his mobile number.
Mobile number, my lord. These young boys, they keep on changing. So the numbers that I have, my lord, none of them are working, my lord. That's a problem for me. And I know the residents, my lord, that I've been once, my lord. But it's a small land. Actually, it's a little difficult for me to locate also, my lord. That's a problem. But in this week, my lord, tomorrow is a holiday. I'll make a personal endeavor again, my lord.
Mr. Sen, in the service papers of the petitioner, there will be some list, names of nominees and so on and so forth, the address, contact number. Why don't you help Mr. Yubin? Why?
Yes. For the purpose of filing substitution.
No, for the purpose of trying to find out who is there. We're not talking about the substitution per se.
No, since lordship is desiring, definitely. I'll see if any vendor from the service.
No. What we are here is Mr. Yubin is finding it difficult to locate. The relatives of the deceased. His address, his contact number, everything is not there. He could not even locate the. So in your service papers, definitely there will be some contact number of nominees there. You pass it on to him. Let him contact.
My lord, that would be a great help, my lord.
I'll do it, my lord.
On premier by the petitioner, this is matter of 2 weeks.
2 weeks, my lord. Sir, I'll